Good morning, good afternoon to our colleagues across Indian country today. We have a really awesome presentation, I think, lined up for you. Many of our colleagues have reached out to the foundation or through the National Tribal Land Association with questions, concerns, challenges relating to HEARTH Act regulations around leasing, in addition to some of the differences between that and BIA. Today, we have a really great presentation put together by two presenters that many of you are going to know about. They may sound familiar. Jeff Keohane is of counsel with Schwabe, Williamson, and Wyatt. I've been working on various HEARTH Act pieces for a little while now. And Karen Woodard is the realty administrator and a little bit of everything administrator at the Morongo Band of Mission Indians. She's also a board member with the National Tribal Land Association. So I'm sure you've seen her on these calls, but also at our annual Tribal Land Staff National Conference. So those are your presenters today. Before I hand over the talking stick, I'm going to lay out just a few pieces of useful information that could be helpful for you today. One, if in fact you would like to contribute through a comment or question, I encourage you to do one of two things. You can put it into the chat feature, okay? And at that time, throughout the presentation, one of the presenters will see the question or comment and be able to address it as relevant to the presentation flow. But you may also raise your hand and communicate that way. Everyone is force muted. So when we see a hand and I have the presenter tell me to say hello to or unmute somebody, I will do that for you. And then you will be able to communicate with the group. So those two ways you can do things. It may also be the case that if you write something in the chat box, that one of the presenters decides to call on you to ask you to maybe clarify some comment or to speak more to whatever it is that you're asking or would like to remark on. So just let you know that we're a community of professionals who are really looking to grow that networking opportunity and these educational opportunities, and these webinars are ways to do that. And so we definitely appreciate your participation in this programming, but also those in the past and those upcoming. Speaking of programming, our conference, our annual Tribal Land Staff National Conference, is not far off. Before we know it, the holidays will be here and done, and we'll be into the next year. And then it's going to be work, work, work until we launch our conference at the end of March at Pechanga in Southern California. This year it promises to be a really great presentations and agenda with a very beautiful venue. Throughout today's conversation, I will put into chat the save the date, March 21 to 23, 2023. But that save the date link will be in the chat feature in addition to the link for the call for presenters, so that if you or someone you know would like to put together a panel or present on some topic relevant to the work that we all do in Indian country, that would be a great place to submit that form. If you're interested, but you don't quite know what you want it to be on yet, feel free to reach out to me, and I'm happy to help you figure some of that out, or at least to coordinate some of those issues. And finally, this is recorded, so you and your colleagues can view, review, rewatch it a third time. This presentation going forward, it'll probably be up by the end of this week, but at the latest, early next week. So without further ado, I'm going to stop talking and give the time to our presenters, Jeff and Karen. Thank you.
Thanks a lot, Nicholas. As you pointed out, I'm Jeff Keohane. I am an attorney, and I will try not to sound so much like an attorney today. I am going to do sort of the more general HEARTH Act information, and then talk about what it is, what the approval process is. Maybe talk a little bit, depending on time, about some high points of things in the approved tribal regulations that have been posted. and hand it over to Karen to talk about what happens when the rubber hits the road. So her experience with getting Morongo's HEARTH Act regs approved by BIA and and what it's like implementing them, which I think I'm looking forward to most. I'm certainly less familiar with that end of things, being outside counsel. So before I really start, though, there's one thing I ran across. You all may know about this, but there's a HEARTH Act overview for tribes being done by the BIA on October 27th that you may want to sign up for. And that's a link I just put into the chat. So I think both Karen and I are happy to answer questions as we go along. As Nicholas said, you can raise your hand. I don't know really what how to answer questions that way, but if you put something in the chat, I will try to respond to it. So what is the HEARTH Act? Everybody probably knows by now, but I have forgotten what it stood for, which is the Helping Expedite and Advance Responsible Tribal Home Ownership Act of 2012. Now, I don't, it's interesting to me to go back and remember that it had to do with tribal homeownership. In fact, the way that most of us interact with it is not from that side, but from most tribes have been looking to enact tribal business leasing regulations as opposed to residential or the raft of other types of leases that are possible on tribal lands. What is the HEARTH Act to me is one of the four main ways that I can advise a client how to avoid having to go through BIA approval processes for leases. The other ones are, tribes have assignment policies. Some tribes have Section 17s that manage their own trust lands. There's one tribe has a tribal energy development organization, Red Lake, which can do, so they are able to, or will be able to soon do their own energy leasing and rights of way. And then there's the HEARTH Act. And it's, if you go to the BIA's HEARTH Act website, there's a ton now of tribal regulations there. And to me, that's the most informative place to go to see how you might want to go about implementing the HEARTH Act, is to see how other tribes have done it. The statute itself is pretty straightforward. It's 25 USC 415 H, and basically says that for any type of lease that's possible under 415A, a tribe can take over leasing approvals. Fairly straightforward. The list of types of leases under 415A is broad. Public, religious, educational, recreational, residential, business, grazing, farming, including natural resources incident to those leasing decisions. So that covers basically any kind of lease, except, and then it's called out separately, says that this doesn't, the HEARTH Act leasing regulations can't apply to exploration, development, or extraction of any mineral resources. That's for most of my clients who are on the West Coast, that isn't as big a deal. But I know for some tribes that's a large gap. The other elements to it that are significant for our purposes are that the business and agricultural leases can be up to 75 years or 25 years with 2 renewals. So effectively 75 years, but with two times to stop and think about whether to continue. All other leases, the public, religious, educational, recreational, and most importantly, residential, can be up to 75 years in one term, which is a significant improvement for most tribes. Some tribes already had lease terms much longer than typical through the Long-Term Leasing Act. So Congress also made the approval requirements fairly simple. Basically, they have to do two things. They have to be, and I'll talk about in a minute how BIA has made it a little more complicated, but the two things. One is to be consistent with any regulations under 415, which means essentially Part 162, the leasing regulations in the CFR. And one of the things that you'll see as you go through HEARTH Act guidance documents and how-tos and so forth is repeated over and over again, is that as part of the debates about the HEARTH Act, it was Congress stated clearly, as Congress ever does, that it's not a meets and exceeds standard. So it's not like some of the other situations where the tribe has to enact regulations that are at least as stringent as the federal regulations in order to take them over. Instead, in this case, it has to be consistent, which, as BIA has actually acted on that and made it so that it does approve tribal regulations that are quite different from Part 162, and but what consistent is a fairly loose term. It's getting to be now with the nearly 10 years of implementation, consistency can be seen by looking at a number of the approved tribal regulations, which show you the wide range of things that BIA has found to be consistent with 162. The other major part of the approvability of tribal regulations is the environmental review process. So one of the main, to my mind, two of the biggest problems with leasing right now for tribes that don't have HEARTH Act regulations in place is that having to wait for BIA to approve leases, them getting in the way of the tribe negotiating the leases the way they want to, so 3 out of 2. Sorry, I can't count. The third one is then dealing with NEPA compliance when that's necessary. And so that is the one of the two parts of the analysis that Congress put out in 415H. Said that in order to be approved, the tribal regulations have to be consistent with Part 162, but they also have to provide for an environmental review process. The environmental review process is abbreviated in the statute, and it's also when you take a look at various tribal regulations, you'll see that they've been further abbreviated in those tribal regulations to make it much less cumbersome. So the first part of it is that there has to be the identification and evaluation of any significant environmental effects. And that's essentially the FONSI, EA, and EIS process. The second part of it is that there has to be opportunities for notice and comment to the public, so that the public is informed of and has an reasonable opportunity to comment on any significant impacts, and that finally that the tribe responds to those comments. It doesn't, it's important to note that while that those things are required, there isn't a requirement that there be an appeal process, or that and most notably that there isn't there isn't a requirement or the ability under federal law to then challenge that decision. That's entirely left up to the tribes. And that's obviously for those of us practicing in Indian country, that's a vast improvement because it means that, you know, a controversial development can go forward. The environmental impacts of it can be evaluated by the tribe itself, and then whatever whatever the tribal decision is about how to deal with those impacts is then up to the tribe, and whether to allow appeal of that is up to the tribe. Question, Cheryl Craig asked if tribal property is the public. Oh, if tribal property is the public just considered tribal members. It's in some cases, it's interesting. I had approached this originally thinking that the public, that the public, as it's called in the statute, would probably be deemed to mean everybody in the local area. There are tribes, however, that have had their regulations approved where they simply give notice in the tribal newspaper. So I think that you would have a hard time arguing that members of the non-tribal public could not comment on something, but you can manage to a certain degree, it looks like you can manage to a certain degree who actually gets notice of what's going on by determining what your public is. So in the case of a couple of tribes, they simply publish in the tribal newspaper, which I don't know whether it has much of a circulation outside of their reservation, but it might. I think that the safest way to, the most conservative way to do it would be to provide for public comment on a website, which is, I think, one of them. I haven't counted it up with all of the different regulations, and one of the things that I had the ambition to do originally was to go through a lot more of the tribal regulations and see how people were handling things. But my anecdotal data is that the most common seems to be publishing it on the tribal website. So hold on a second. As I was saying a little bit earlier, I'm hoarse and I don't know why. So those are the basics of the statute. In terms of assembling the documents that you would want in order to understand the HEARTH Act more generally, things that I find useful are, of course, Part 162. So the BIA's on leasing regulations, with which the tribal regulations have to be consistent. Most important, however, is the checklist from the HEARTH website, which I'm going to put into the chat. This is the link to the BIA's website, not specifically to the checklist, but the checklist and various other useful documents are at the bottom of that page. So the two things that I think are most significant if you're deciding to draft your own HEARTH Act regulations, the first thing I would do is, you're probably all very familiar with 162, but if you're not, become familiar with it and find the parts that you hate the most and cross them out. The next thing would be to look at the checklist, make sure that anything that you've crossed out isn't on the checklist, because those are the things that the BIA will be looking for to determine consistency. And I'll talk a little bit more in detail about the checklist in a few minutes. The other thing is other tribes regulations, and you'll find a link on that page that I sent you that has a, I think that you then link to yet another page that takes you to other tribes regulations. There's also an expired national policy memorandum, which you can find by Googling. And it's still in, even though it's expired, it's been expired for 8 years, still seems to be in use. So there it is, NPM, National Policy Memorandum Trust 29, very little. Okay, so we have a comment from Steve Mintzner, sorry for messing up your name. If the tribe uses public utilities or lease impacts public easements like roads, so forth, should notice be written notice, especially if other federal and state laws require written notice. The HEARTH Act doesn't supplant other federal and state laws. So if you're if there are laws that you know that require notice for other reasons, then certainly you would have to continue to comply with them. The HEARTH Act doesn't allow you to avoid anything except to some of the things that are in Part 162. So, you know, I can't speculate as to the various uses you're talking about there, but you know, if there are public utility issues, then those would be governed by, you know, if they're under state jurisdiction by state law, if they're under tribal and federal jurisdiction, then under federal and tribal law on notice requirements. Maybe we could talk more about that later on. So this is a little bit, I was going to talk about how to, and my experience has been, and probably you know, anybody who's been around for a little while has had a similar experience. You know, the in drafting a tribal code or ordinance or law or whatever your tribe happens to call them, you know, it can be a long iterative process. Sometimes, you know, you get fortunate and you call in outside counsel like me, and you just say, draft us a code, and then we draft you a code and bring it back, and everything's perfect. Which is, I mean, jokes don't work so well on Zoom when everybody's muted, but obviously that's not how it works. Even if you have outside counsel come in and do something like that, you're going to have to, you know, there's going to be an iterative process. It's just that outside counsel doesn't have to see all of that. You do. So for a first draft, what I suggest is that, you know, you decide off the top who's going to draft the first draft. And there are arguments for having your in-house counsel draft it. There are arguments for hiring somebody outside like me to draft it. But the strongest argument I find is in favor of land use professionals going ahead and doing the first draft, because you all are the ones who are most familiar with how this is working under 162 and what the biggest problems are. Tend to have a better sense, particularly than outside counsel, of you know, how the tribe likes to go about drafting new codes. So whether it's in-house counsel or a land use professional, you know, it's, you know, strikes me that that's the best place to start. Now, obviously, you know, Karen may have a different view based on her experience, having worked with both in-house and out-house counsel. But the next step, I think, you know, whoever is drafting it is going to need to assemble those documents that I called useful earlier. You know, so Part 162, the checklist from the HEARTH website, other tribes regulations. This takes a little more time. You have to plow through a few of them to see what some of them are like. I am particularly liked, not because Karen and I used to work together, but I liked Morongos. I like some of the short ones like Pachanga or Pala, and also Northern Cheyenne, which is an extremely long and involved one. So those, if you look at a sampling of them, you get a sense of the range of options that there are. Then the checklist, the other tribes regulations, and the expired policy memo are useful to have on your desk while you're doing it. So I'm glad somebody caught my calling myself outhouse counsel. So as I said earlier, you want to identify the things that are most annoying about 162. You want to figure out, some of the duplicative things in there that can be taken out. You work with, and most importantly, work with your elected officials to figure out what's most important. And if to them, what is it, a business only leasing regulation, or is it going to include agricultural? Will it be energy related? Will it also have the whole long list of the other, public, recreational, and so forth types of leases in it? I won't say by far, but certainly the largest chunk of tribal regulations so far have been just business leasing. And that's understandable because it's the most important for economic development. It's also a business leases are the most flexible type of lease in my experience. So if you're going to do just one type, business would be the one to start with. There isn't a particular, there's a strong argument to include all the different types of leases, because once you've done once you've actually written the procedures for one type of leasing, adjusting them for the other types within the same statute or ordinance are not that much. It's not that much more work to do it. So in a sense, it makes sense to just take it all away from BIA at once, rather than having to determine on a case-by-case basis, is this lease a business lease, or is it agricultural? Is it mixed? Is it, and then have to decide, okay, well, this one goes to BIA, this one stays with us. Also, I would say, once you've decided on what your base document is going to be, and yes, I'm talking about plagiarizing, whether you're using another tribe's regulations as the basis for yours, or whether you're using Part 162 as the basis for yours, I would say, just go crazy, change it the way that you would like it to be done. And then once you've gone crazy and done a lot of changes to it, or simultaneous with that, keep the checklist by your side, so you can say, okay, well, this might be, we might not be able to delete this. Generally, though, if you don't delete it, you can mend it quite a lot to be very different from Part 162. That said, the caveat is that the more it is different from Part 162 and from the tribal regulations that have already been approved, the more likely it is that the BIA will have something to say about it, and more, may take them longer to approve it. So obviously, then we're talking about the iterative process. In second, third, fourth, however many drafts that you want to do, within the tribe, there will be, I work with tribes that have, no sort of public process associated with enacting codes. They simply, anybody who's, any tribal member is welcome to show up at the tribal council meeting and, have input into how the code is being drafted at the appropriate time. And then I have other clients where they the membership is consulted quite thoroughly, and even some where the ordinance is actually sent to the general membership for adoption. So, whatever your particular tribal structure is going to determine how you get to draft 2, 3, and to your final draft. But I encourage people to pass these things around, get as many eyes on them as possible, so that there isn't a surprise when you get to the final stage and are ready to send it off to the BIA. So that's a timely question from Nicholas. It's the Realty Office HEARTH Act specialist who does it. I can't tell you who that is at the moment, but you basically, as the most recent process was to actually mail a physical copy in, and then follow that up with PDF and Word versions by email afterward, and then basically the realty and the solicitor then review it in tandem or one after the other, it seems like, based on the amount of time that we had to wait. Then basically what the BIA and the solicitor's office are doing during that time is going through your HEARTH Act regulations section by section and comparing them to each one of the elements on the checklist. And then the next stage is okay, Scott Midsner's question I'm going to have to answer, hold for a second. So they look for consistency, basically using the checklist. We'll talk about the checklist a little more in a second. Then if they find there are things that are unclear, or that they question the wisdom of, neither of which is really a basis for disapproving a regulation, they may send it back to you. The real basis for sending it back to you is that it is inconsistent with with Part 162 based on the checklist. Now the checklist is an interesting thing just to bring up. Well, at least for me as a lawyer, the checklist is not a regulation. It does not have the force of law. But like so many things with the federal agencies, it's a policy document that everybody treats as if it's law. And if you want to get along with the BIA, if you want to have your HEARTH Act regulations approved within a reasonable amount of time, you should, unless there is a very good reason to, follow the checklist as if it were law. But it is most emphatically not law. It is just a policy document, and the BIA can deviate from it because it's a policy document. Theoretically, we in the public, tribes and so can deviate from it at any time we want. And that's not where the balance of power is, though. The BIA, however, if they're in a new administration, could simply walk away from it. It's not bound by it at all. So, and then once if they send it back to you, there will probably be a stage where you have to then take it back to tribal council. Tribal council will then amend it and send it back to the BIA. Once it's final, it'll be sent to the Assistant Secretary, Indian Affairs, for final review, another round, and then approved at that point. So let's see, Scott's question was, usually a lease is in rem and a leaseholder can sublease or assign a lease. Yeah, so is lease flipping allowed under the Act? I could see ways where you would have tribal regulations that prevent that and that permit it. So uh, under the HEARTH Act, there's you could draft. So this is a longer way of answering your question rather than just yes or no. HEARTH Act regulations that are consistent with 162 drafted one way would say that assignment of a lease would only be permitted with the consent of the tribe, adding another layer of review. Most of the HEARTH Act regulations that I've seen, however, don't simply allow assignment of leases. So the if as you're talking about here, tribal good old boy gets a lease deal from the tribe and then sells his leasehold rights to someone no one knows or trusts for a profit. That would come down to something that you would want to address in the HEARTH Act regulations adopted by your tribe. This could be handled by either saying that all assignments would have to be approved by the tribe, or that an assignment could be revoked by the tribe upon a finding that it was not in the tribe's best interest. Another question, what happens if they're not in good standings with BI? Will they be allowed a HEARTH Act lease? I'm going to interpret this as if the lessee, if the person who is renting the land is not in good stead with BIA, it's of no concern to BIA once these are HEARTH Act regulations are approved, because BIA has no role in approving. BIA could weigh in and say this person is a bad actor. BIA could make life difficult, because one of the things is that one of the things that's required for consistency is the ability of the of DOI to come and enter and inspect. So they could come and inspect if they find that somebody that they would not have leased to has been leased to by the tribe. They can get, there are ways for them to get involved, but as far as I know, there's no way for them to simply say this person is this is a this person is persona non grata and should not be allowed to lease. So is lease flipping the same as subleasing? That's lease flipping is not a term, is not a legal term. So if you you could profit from taking a lease that has been granted to you by the tribe and then assigning it in exchange for more rent than you are paying to the tribe, or you could sublease if that's permitted under your tribe's HEARTH Act regulations to somebody for more than you're paying for your lease. Unless there is, unless that has been anticipated by the tribe and been banned, or unless if there has been a provision written into the HEARTH Act regulations that says that all leases and all subleases and assignments, which have to come to the tribe. I should have said that at the beginning. That any of those can be overturned by the tribe based on it not being in the tribe's best interest. So let's see, we're at about 40 minutes. I had just a reminder that the criteria for approval are relatively simple. The things that BIA is supposed to look for are whether the terms are correct, the term of years are correct. So you're not trying to lease beyond 25 or 75 years, depending on the type of lease. You're not trying to address, this is something I should have mentioned at the very beginning. HEARTH Act regulations cannot apply to individual lands. So individual tribal members' lands are not subject to HEARTH Act leasing. Can't address mineral exploration, development, or extraction. But the two biggies are the environmental process and consistency with Part 162. Yeah, that's a very good question. So once the regulations are approved, is there a process in place if the tribes want to make changes to the regulations? Is it allowed? Um, there is a requirement in the checklist that substantive regulations, which is not well, isn't defined, have to be approved by the BIA. The non-substantive ones, changing the organization and so of the code and so forth does not need to be. I have argued that things like notice requirements, changing the length of time, particularly extending the length of time that people have to comment on things, or to change the who is the approving officer or official that for a lease, things like that should not have to go back to be approved by the Department of the Interior. But it's a little bit of a fuzzy area because, of course, changing, to some people's minds, comment period is actually substantive because it is too short a comment period robs people of their ability to comment on a proposed lease. Shortening the amount of time for an appeal may lead to somebody missing their time, makes it more likely they'll miss their time for an appeal, in which case they could lose the ability to lease, or they could lose other important rights. And so generally, though, I counsel that you can probably change the notice requirements and things like that without having to go back to Interior. Other things like changing what the best interest of the tribe is, how to determine that. Those types of things are definitely substantive and would have to go back to BIA. So I was going to go over the checklist criteria, but given that I've used up half the time, I think what I'll do is I'll hand it over to Karen, and then if we have time after that, we can go through some of the requirements of the checklist. Does that sound good?
Yeah, we can. Yeah, I can definitely go over the checklist. And again, you guys can, if you go to the website, the BIA's website that Jeff put up there, there is a lot of good information on there for preparing your leasing regs. And I was just noticing we still had some questions in the chat here. And one of them was, can a business lease be used for right-of-way use, say telecommunications, the tribe owns? Are there specific requirements or, I'm sorry, special requirements or specific language required to cover this? So Jeff, you might, I know right-of-ways do not apply to the HEARTH Act, but it's confusing. If it's a tribally owned facility, I don't think there's a right-of-way needed.
Yeah, that's interesting. You could, you don't really need to go through that process for just bringing telecommunications lines, say, to the tribal offices. I think that the BIA might have something to say about that if you wanted to. Certainly, if you wanted to use a lease in place of a right-of-way, that can be done. You can lease a 10-foot by 10-mile strip of land on tribal land to a utility if you wanted to grant them lease rights instead of right-of-way rights. And that would be, the BIA might get annoyed by that. People who are a little more hidebound might be, have some difficulty with that because they say, well, that just looks like a right-of-way. But you can, the tribes are free to lease a long, thin strip of land if they want to. So It's just that by dint of practice, particularly in utilities like easements better because they tend to be permanent or at least of a defined time. The advantage of now that we're in HEARTH Act territory, we're talking longer terms than we used to about leaseholds. So at least for most tribes.
Right. Okay, thank you. Okay, so there was a question too about submission, who reviews it, where do you submit it? The sample checklist that's been provided now is going to be used by your regional office. So when you submit your regs, you're going to submit it to your regional director. That regional director is then going to have their realty officer, or they may have a team of realty people that might go through the lease. So the sample checklist, is to go over, the tribal name, how are they federally recognized? When did they get federal recognition? They want a tribal resolution to accompany the leasing regs. They want to know what type it is, if it's agricultural, residential, business, if it's going to be under energy, being wind or solar, whether it's, for public, religious, or education or recreational. So then they're going to go through their required definitions and they're going to mark so for agricultural land, they're going to mark what article and what chapter and section is your regs address, agricultural land. Is it suited to tribal trust land? Is it used for crops, livestock, any other agricultural type use? They're also going to look at assignment. Can the lease be assigned? And again, usually that's addressed, in my experience, it's not really addressed in the regs as it is addressed in an actual lease document. And for Morongo, we prefer to put it in the lease document because we do want, if that lease is going to be assigned, we prefer to have approval of that. You don't want to be able to just assign a lease to just anybody. You want to know who's taking that lease over. They're also going to look at what's the best interest of the tribe, which is kind of interesting. I thought the HEARTH Act was supposed to be the best interest of the tribe, but again, here's BIA with the big brother looking out for us. They want to know if it's the highest economic income. They want to know if it's preserving and it's adding value to the tribal trust land. Does it increase employment? Does it preserve the sovereignty? They're also going to want definitions. What is the definition of the lease, the lessor, the lessee, the leasehold mortgage. They are going to make sure that the LTRO is defined, because when you get your lease regulations approved, this is submitted to the LTRO. The LTRO, then your leases go directly to LTRO, and they have to record those leases onto your tribal trust tract. So there's a process that they're actually implementing now to actually be able to encode a lease into TAMs. They're also, again, environmental review is going to be a big deal. They want to make sure that it's the public and comment. And again, that public could be, and for Morongo, we publish on our website the FONSI itself, as well as we make the document available. So we can make the document available at our tribal administration office, or we can make it available on our website, or perhaps community center or a library. But there will be public comment on your, not so much on the regs, I'm talking about if you do a project, you have to be able to manage that. They're going to look at if there's a significant effect on the environment. And as you know, today, that's really important for climate change and all that. They're also going to look at the sublease. They want the tribal land defined. So if you get into a tract of land, they're going to want that survey or GIS map. They're going to want something that actually defines that area. They want to know what that tract is. So they're going to want a title status report that's attached to it that says this tract is the one that we're going to lease or we're developing. They'll be looking at that. Oh, let's see, they have all kinds of things here that they're going to go through. Let's see, they want to know, again, regulations, what identify to what lands the tribal regulations apply. So if you have a ordinance, If it's an environmental ordinance or if it's a land use ordinance, they want to know if those apply to this particular tract or to these leasing regs. They want to know what the effective date of the regulation is, the date of secretarial approval. They want to include provisions addressing the tribe's authority to enact the laws. So if you have a constitution or bylaws, they'll want that. State that all the major substantive amendments to the Tribal Hearth Act are reviewed and approved by the secretary. And I noticed we had a question here. If you do want to amend your, or if you get a Hearth Act approved and you want to amend it, I think that was the question. Yeah, once they're approved, is there a process in place if the tribes want to make changes to the regulations? Well, we just went through that process. If you change your approved hearth reg, approved leasing regs, to change anything in it, it will have to be amended and you have to go through the process again. So I strongly suggest that you put, while keeping everything you want in that leasing reg, also keep it broad so you don't have to go back for amendments. And we learned that because, like, don't put your process, your internal process in the leasing regs, like saying, you know, if we get an application for a lease, we're not, you know, our environmental department review or our cultural department review, take those items out. They don't need to know all of the internal process. And let's see, what else do we have here? State the purpose of the lease and the authorized uses of the lease premises. They want a definite term. And let's see. It provides for an options to renew. It's quite a list here. They also, when it comes to your negotiating the rent or the lease, you know, rent for the ground lease, they want to make sure that there was options that the tribe looked at. So was there an appraisal or were there certain negotiations that took place? That should be addressed in a resolution that the tribe has negotiated and they feel that that's in their best interest. So if they want to waive the appraisal price or, you know, the appraisal, they can do that, but they want to make sure that the tribe has looked at it. They want to know if the lease payments are made directly to the tribe or if they're going to be processed through the, what is it, BAFTA now, the Bureau. Gosh, I can't remember it. That's a whole nother session. They want to know how adjustments are made as to the rental reviews. Are we going to do adjustments? Are we going to have, you know, the CPI? We're going to increase, you know, annually every 5 years or whatever that is. There's going to be enforcement provisions. So they're wanting to know what happens if there's illegal conduct, how the tribe will deal with that. What ordinances and laws the tribe has that will address that. And again, this secretary has every option to go in and enter the lease premises. They want to make sure that that is clear. They want to know if the lease premises are within the irrigation project or drainage district, operation and maintenance changes that occurred during the lease term. There's just a you know, required insurance provisions, indemnity provisions, those all need to go in there. And let's see, I see some more questions coming up here. Let's see, just a comment. When a tribe has leasing authority, is recording at the BIA LTO required? Yes. So you will still submit your lease to the Bureau, to the realty officer in your region, and then they will submit it to the LTRO for recording. And then we have for a 184 loan, tribal member selling home on leased land. The tribe is providing lease. How do we verify the lease or legal description is acceptable with BIA prior to closing? We are finding issues after we close. Lease and mortgage is denied for recording. It's interesting. Tribe is providing the lease. So I'm assuming that this is residential leases under a Hearth Act. Okay. That lease, the leasehold should have came with a legal description. And it should have been either reviewed for accuracy And it depends on, and this also depends on region to region. Some regions require what they call a legal land description review process that goes through the BLM. And there's a certificate that that BLM bill surveyor will provide. And that would accompany that legal description saying, yes, this has been confirmed, it's accurate and can be recorded at the LTRO. If there are issues with the survey, then I would suggest that they do submit that to the BLM bills in that area. Because if there's corrections that need to be done, then that gives you that extra paperwork to give to the surveyor that says, hey, we need these corrected. So, but then there are some agencies that don't require LDRs. So it just depends on your region, but definitely work with the realty officer on that. And leases should not be, if a residential lease is being approved under the HEARTH Act, and correct me if I'm wrong here, Jeff, but there's no reason for the BIA to reject it. It's going straight to, it's getting approved by the tribe, and it's going directly to the agency to say, record this lease and record this mortgage.
That's right. Yeah, no, the BIA doesn't have an approval unless, I mean, you could imagine a tribe that wanted to, for some reason, include the BIA, they could. That wouldn't be outside the scope of consistency with 162, but it would be, in most tribes cases, in any imaginable tribe really, would not want BIA to be taking part, because one of the reasons was just to get them out. Also to change the substantive requirements of the leases, but also just to get things done quicker. The one thing I would say is that there is a portion of 415H called 415H8, which has to do with if someone wants to appeal to the Secretary of the Interior that the tribe is not complying with its own HEARTH Act regulations, it can do that. It can go to them, but that's kind of a nuclear option, because if the tribe doesn't conform to its own regulations, BIA can withdraw them, and but it's not exactly for a lease by lease basis of appeal. So basically, no, there isn't a way to get BIA involved in a particular lease decision.
Right. Thank you. Okay. And then we have another comment here. I've asked tribes to think. Some states have laws that allow property owners like a tribe to give notice that an easement or long-term lease can be declared abandoned and terminated with proper notice. Yes, you can abandon an easement. You can terminate it with proper notice. HEARTH Act, who is responsible for compliance? Well, under your leasing regs, you, the tribe, are responsible for compliance. So hopefully you have a realty department or a land use planning department that will comply or check for compliance as far as what they're using the property for. Does it comply with what the other in the lease, if they're using it for that? So yes, you, the tribe, would be responsible for compliance. This is here. I refer to First American Tribal Lands expert. Title searches and policies are overdue. So are we talking about title status reports? You don't need a certified title status report. You should be able to get a title status report directly from your agency. Or for instance, in Morongo, we do our own realty program. So we actually issue those TSRs. And then so implementation, I want to get into that a little bit after, this checklist we can go on for hours with, but what we're concerned about is implementation. And with what we have found is that once we get that leasing regs approved, now we're ready to go. We have a couple leases out there that are waiting to get approved under that. So we're looking at making sure that we've followed all the environmental policies. We're issuing our own FONSI. We have to publish that, as well as we have to do the tribal resolution stating that the tribal council has approved the lease. They've waived, that they've negotiated for the best interest of the tribe. We also have, our tribe does all of our land use that has to be approved by our general membership. So we have to make sure that ballot measure has been approved, that this area that we chose to do this lease has been approved. There's also, we need to make, your environmental document available for that public comment, whether it be, tribal members, or if you're, might be an outside jurisdiction, a local city, might be utilities that want to comment on it. So you want to make sure that that's available. And your environmental document should go into, for instance, if the utilities are not a tribal utility, and they're an outside entity that you're going to another jurisdiction, that should be stated in your environmental document. That will help you with the environmental clearance when you have to go to the right-of-way process with that city or other utility that you might have to deal with getting utilities to the project. Land use is another thing that tribe really needs to think about. I know for us, master planning and specific planning has really become to the forefront. We want to do, while we want to do leasing and for economic development, we want to make sure that they're all in compliance, that they all match what we're actually doing in the area, whether it's retail, commercial, maybe it's, warehouse or something like that. But you just want to make sure that that land use, you have a group that's working on that land use, understand where your utilities are, you understand where your infrastructure is to get to that project. And with that, I think that's about all I need to cover as far as implementation. And we've got some time left here for questions, comments. Jeff, do you have anything else to add?
No, well, I have other things I could add, but I think that questions would be probably more useful to the audience. I think we have a couple of questions right now. How long is the average timeline of BIA lease approval for non-HEARTH Act tribes?
My experience has been anywhere from 2 to 3 years.
Yeah.
That's, that's a real problem when you're doing economic development and things change out there when you're doing your market data and your research, things change a lot within 3 years. If you signed up for something in 3 years ago, it may be totally different today. So 3 years is a long time.
Yeah, I would, just as a caveat to that, I would say that it has a lot to do with the complexity of the lease and how important it is, or how pro forma it is. And I think so there have been instances recently that I've been involved with where we were able to get leases done, get them approved by BIA because they were not terribly complicated within a couple of months. But that was because they already knew what they were looking at and had, we were essentially, referring back to something that had been done before. It wasn't new to them. Whereas things like a lease for a large commercial facility or a mixed use development will take a long time because it's confusing to them, and there's a lot of things for them to, there are a lot of things that they're required to look at, and then also they just don't have the expertise to really understand what they're looking at a lot of the time.
Yeah.
Yeah.
And I think the second half of that question, how long is the average timeline of a tribal lease approval for HEARTH approved tribes? That again depends on the circumstances. If it's a business lease, it's going to be negotiations between the lessee and the lessor. That sometimes can take time, 6 months, average 8 months. But once it's gone approved and it's been approved by your tribal council or your general membership or whatever, the next step would be to do your environmental process. And of course, get that out for public comment, which, is usually a 30-day public comment period. And then you have 30 days to respond to any comments. So it's certainly quicker than, 2 or 3 years for sure.
Yeah. Yeah, I mean, that's one of the biggest, there are tribal sovereignty reasons for enacting HEARTH Act regulations, and there are, substantive reasons like not wanting to be bound by 162 regulations. But, really the big driver for a lot of tribes is the difficulty, as Karen was talking about. But if you have a deal you want to do, you want to get it done within the time frame, when the economy is still in the same condition as when you negotiated the deal in the first place. I mean, we've seen what happened in the last couple of years. Imagine if you had negotiated for a significant development in the end of 2019, and then you had to wait through 2021 and 2022 to finally get a word that your development was approved. Well, we're not in the same economy at all now. And so it's, it would be of a great advantage if you're looking at significant, particularly in significant economic development, to be able to control the timeline. You still have to, there's still things that you have to do, the environmental and the internal processes of the tribe, but that's in a matter of months rather than years.
Mhm.
So
Quite sure what if I understand that comment. Grandfather.
well, I could take a stab at it. I'm not sure that it's really a question, but that is something to be considered, is when you do change your leasing regulations. Typically, the understanding would be that leases under the old regs would be still, things that are substantive to the lease itself, that were not drafted into the lease, but incorporated by reference or by dint of the regulation, would continue, notwithstanding the new regulations. But then the new regulations would govern things like renewals, if those were not governed by the lease itself, things like that. I think, that's an interesting, the constitutional prohibition against impairment of contracts is the federal constitution. It would be an interesting sort of law school hypothetical to say, well, how does the Indian Civil Rights Act affect that? The ability of the tribe to go ahead and change contracts through regulation after they've been enacted. And I think that most tribes would not interpret their own laws such that it would, deny people due process of the changing of their leases just by the tribal council alone, because that would strike most people, I think, as fair play. It also would, it might get the tribe marked out as an unreliable partner for businesses wanting to do business in Indian country. So.
Okay.
So that next one, the requirement for a 184 loan, I think is aimed at you, Karen.
Yes, I see that. Hi, Dark Feather. So under the HEARTH Act, it would be tribal trust lands, of course, and it'd be leaseholds. It wouldn't be it's a situation on a divisional allotment. But if there's a life estate showing on a title status report, then that life estate has every right to consent, and they would have to be part of the mortgage. Yes. Anytime you have any type of special interest on a title or an allotment in different owners, they all have to consent. They all have equal consent, even if it's a life estate. Yeah.
So do we have any more questions? I don't know how you tell if people have their hands up, but
I haven't seen any hands raised yet.
okay, good.
He's done.
Hmm.
That's a good question.
Yeah, there ought to be one.
There ought to be, yeah.
I looked around in preparation for this presentation for any sort of, articles talking about, implementation over multiple tribes, and I couldn't find any articles about a single tribe, much less multiple ones, although that could be about my searching abilities. But it strikes me that given the the sort of opacity of the of tribal leasing processes, I mean, it's hard enough for people to study the BIA process. Once it goes completely in-house to a tribe, these things, you'd have to be, the only public part of the process necessarily would be the environmental. and unless the tribe has decides to add other public parts to it, such as putting things out for competitive bidding and things like that. So it would be a great idea for somebody to do that, because among other things, I think the HEARTH Act is a good idea and ought to be expanded. And I think that the Harvard economic development folks, I can't remember the name of them, but the institute at Harvard that studies that has shown repeatedly that anytime that tribes have greater self-government over, it leads to greater economic development. And this has been true. I mean, not every tribe that takes on self-government succeeds, but predominantly those that succeed, disproportionately, I should say, not predominantly, disproportionately those that succeed have elements of self-government that they've taken over. So, examples include, I mean, particularly the land space we're talking about. Morongo has taken on realty, and I think that has been very successful for them.
Mm-hmm. Yes, it has. We actually are contracting with other tribes, so yeah, it's been very successful. Yeah. Okay.
So if we don't have other, here we go. We do have other questions, because I have a couple things to fall back on. There's also the possibility, we could maybe talk about environmental on a different day, or the appeals or enforcement process. Or you can contact me or Karen. I just shouldn't volunteer Karen. You can contact me.
Yeah, they're welcome to contact me as well. I would say, okay, Scott, you can do that. Scott, you go.
Oh, interesting. What are common reasons, if any, why tribes may not want to apply for and become approved for HEARTH Act? I messed up that question, but I did briefly think about that, and I didn't come up with any answers for why you wouldn't want to, other than if you don't have a realty office and the staff to actually take. If you had significant leasing and you didn't have significant staff, you might not want to take it on. But that strikes me as a rare circumstance.
So, but there was another thought that I had too, and I don't know if this has been happening to others, but I have heard that some tribes are having difficulty with financing because it's not a BIA approved lease per se, that they're having difficulty getting financing for projects.
Right.
So that might be another reason they may not want to do a HEARTH Act. And I don't know how you fix that problem. But if it's recorded on title, to me, that says it's BIA approved. And that's all that the lender should be looking for. But that would be one of the other concerns. How many realty staff are needed for the typical HEARTH approved tribal land office? That's a really good question. I can tell you from my experience, we have 2 people in our realty department, plus we have an environmental staff that has to, assist with the preparation of the EAs, the review of the EAs, the, preparing the FONSI and publishing the FONSI, commenting. So at a minimum, just having everybody to oversee the approval process for a HEARTH Act lease. I would say it's probably good to have a minimum of 5. Now, there is some people probably could do, one person could do it, but it might take a little longer. Geez, but no laptop. Okay, doesn't matter where the tribe gets the laptop. Oh, Dark Feather, you just need to call me. Yeah, HEARTH Act approved leasing regs are not allowing people to have access to TAMs. That's a whole nother process that the tribe has to contract that function from the Bureau in order to get access to TAMs and to get a laptop to access TAMs. So that all has to be approved. Yep.
Which there's an interesting question. If your tribe has not compacted any of its realty, is it possible to apply for HEARTH Act? Yes.
Mhm.
The two, just as Karen was just saying, are not the same thing.
Right.
You can do both. You can do one. You can do neither. The HEARTH Act allows tribes. So what if you contract realty services, then you're basically you're doing 162. If you contract realty services and then you get the HEARTH Act, then you're diminishing some of the realty services that you're doing for BIA. You're still doing some of them, presumably, unless these but you're taking away that federal intrinsically federal function of approval,
Right.
and taking that into the tribe.
Yep. Yeah, and there is a process for tribes to gain access to TAMs, and that is access only. That is to view your tribe's land area, and to be able to pull TSRs. There is a process just to get access, and normally you would have to go into the Bureau agency, your local agency, to get that access. Oh, we need to have a whole session on TAMs, I think. Make a note of that, Nick. I really don't know. For just simple access and going into a BA office, I would think it's just a matter of months. It's also, I believe you're going to have to go through a federal backgrounds check, whoever is going in there to access it. That process alone can take 12 months. So yeah, it just depends on how quickly your agency works. Yeah, I can believe that, 2 years. Yep. Yep. Yeah, something's wrong if it's been since 2017. You need to contact that regional director. But yeah, it can take up to 2 years with just the federal backgrounds and then they also want you to have TAMS training. So you have to wait for them to, we have dates for trainings. So. Okay. Looks like we're getting ready to wrap up here.
Yeah, it looks like it. Sorry, everybody just disappeared for me, so I don't know.
I actually had a question for the audience. I want to, is people that are here, have any of them filed for their leasing regs yet? Have they submitted them for approval? Are they in the process? See if anybody wants to answer that.
Feel free to raise your hand if you'd like to contribute via voice. I could ask you to unmute from that.
Just starting. Okay. Okay, good. So we do have some in here in progress. Good. Well, I think it's definitely a benefit to tribes. It might be a bit of a process just to get approved, but in the end, it's worth it. Better to be self-governance.
Yeah, although not literally self-governance, under the act, but self-governing. Yeah,
Self-governing, yes.
Yeah. So there are, I recommend again that people who are interested in this take a look at the other tribes who have done it. Take a look at their regulations, and the ones I mentioned. There's a large chunk of them have been based upon. I don't know what Scott is asking if we're available for referrals. Yes, my contact information should be. I'm sure will be made available by next. And I'm happy to answer any questions people have. But looking at the tribal regs, there's one set that are the largest set are sort of simple and seem to be based on one particular tribe. I haven't gone back through the time frame to figure out which one it was, but they've been very successful at doing the sort of simple approach. Morongo's is very sui generis. That it's its own thing, and includes a lot of Morongo specific procedures. And then Northern Cheyenne was the other one that I mentioned that is a long, extensive, more Part 162 like process. And so looking at those three can give you a sense of the range of potentials. And there is, as Karen pointed out, you don't want to include a bunch of stuff that's not related to a lot of internal processes that the tribe might use, because you might then end up, if you amend those, having to go back to BIA because it might be deemed a substantive change. So it's best to just have, this, even if it's part of a larger title in your code, to have this just be its own thing. You just submit one set of documents to the BIA that just deal with HEARTH Act, as opposed to all the other things that you might want to do with land or leasing. So but I will shut up now.
Well, looks like we have a hand up. I'll unmute Dark Feather here.
Okay, got it. I just wanted to say thank you very much for your guys' time and your expertise. Very, very helpful. Wanted to do a little plug for Karen and Morongo. We specialize in the 184 loan, and I can tell you it's night and day when we're working with Morongo, because they know what they need to do. That helps us on our side for the 184 mortgage. So I just wanted to say thank you very much, Karen, for all of your expertise and taking this time, because there's so many questions. I will be calling you for sure. There's more, but from a lender side, it's very helpful when the tribe has gone the HEARTH Act. I can tell you there's definitely differences that we're seeing. So just wanted to do a little plug. Thank you again for all of your guys' expertise.
Thank you. Thank you very much, Dark Feather. I look forward to hearing from you. All right.
Okay. We had a really great conversation today. Want to express our gratitude to both Jeff and Karen for sharing their expertise and their experiences about HEARTH Act leasing regulations and implementation. It's definitely relevant to have additional sessions on this moving forward. How that might look, we'll see. We'll have more conversations about that, absolutely. And I heard it loud and clear. TAMS is important, and we need to have some training on that. So we'll see what we can do as far as better educating our colleagues on TAMS, or at least some of the processes behind that. And we'll see what we can do. The whole point of this is to provide you with professional development and networking opportunities, so that way we could better build our own capacities. So once again, many thanks to our presenters, and many thanks to all of the participants in today's webinar. You certainly made it even more worthwhile. This presentation was recorded. It will be shared with you late this week, early next week. And please feel free to share that far and wide with your colleagues who may have questions. If you'd like contact information from Jeff or Karen, I'm happy to provide that to you. It sounds like they're both amenable to speaking with you about your questions or concerns, and I'm happy to make that connection if you're unable to get that right here. So thank you very much, and we'll see you next time.